Welcome to the Reducing Risk podcast series from Medical Protection. This is the next one in our series on privacy. My colleagues Sam King and Lucy Gibbard are joining me, Tim Cookson, for today's session, which is on children's notes. Who has the rights of access? And this is a subject of frequent calls to MPS. And there's some very important principles to understand to avoid getting into trouble for release of information inappropriately. So I'd like to point out, first of all, that the Smith family, whom I'm talking about, is entirely fictional, but very realistic. So the Smith family has recently disintegrated. There's a very acrimonious split between Mr. and Mrs. Smith. Their three children, there's Sophie, who's aged 14, Tom, who's aged 11, and Nathan, who's aged 8, spend most of their time with their mother. But they do have occasional weekends with their father, who has moved to a new town, and he also has a new partner. Now, he has actually never brought the children to see the GP. This has always been done historically by Mrs. Smith, and that is continuing. So the split has had some significant impacts. Sophie particularly has had really emotional difficulties following the split, and as a result there have been some issues with drug experimentation and also with sexual activity. Nathan has also reported to his mother that on his last visit with the father, the new partner lost her temper with him, yelled at him a number of times, and then locked him in his room. And after this had happened, the father then allegedly said to Nathan that if he told anyone about this incident, there would be consequences for him. Nathan is not keen on going back to stay with his father, and this information has all been recorded in the notes. So there's the scenario. Now Mr. Smith writes to the practice and he wants a full copy of all the notes. Lucy, your thoughts first of all. Look, he only has the children very occasionally. He's never taken them to the GP. So actually, what rights does he have to getting the notes? There's no practical use to him.
Yeah, but he's their legal guardian. When a child is born, both their parents are their legal guardians. And in nearly all situations, that guardianship is not removed, even when there's been a split in the family and one parent has been given custody. So I think it's a really common thing to get custody and guardianship muddled up. The custodial parent is the person who the children are mostly staying with, and they're likely to be a guardian, but the other parent has the same guardianship rights to the information of those children as the custodial parent. So I think that's he does have the right to a copy of his children's notes, a prima facie right. That right is not an absolute right, and it can be limited. And I think in these situations, that's really what we've got to talk about today. Yes, he's got a right, but that right is limited, and are we going to limit it in this situation?
So Mr. Smith looks after the children, has all the medical care, and yet there's no difference in rights between her and Mr. Smith, who doesn't, in terms of access to the notes.
They both have equal access to the notes. There are limitations potentially for both parents. You've got to look at a number of factors when you're looking at those limitations, including the best interest of the child, the wishes of a competent child, and whether or not releasing what's in the notes is going to do harm to the children. But that's true for both parents. So
hang on, you're making things really complicated here, because look, surely if they've got the rights to the information, then the practice will just release the notes and that's it. That's all quite simple. You're implying that that's not the case.
Yeah, it's not the case, because actually I think the main thing I always think when I'm talking to our members about this situation is you've got to think about that child, and the welfare of the child has got to be at the centre of any decision you make about that release, because the most important thing is that the child's not harmed. And there are situations where releasing notes could actually harm the child. Yeah, I'm going to make it complicated, Tim. I'm sorry about that, but actually it is not simple.
Sam, can you help me here? Can you go through some of the things that you might need to think about then in terms of what is released in the way of notes to the father?
Sure.
And we can expand on some of these things in more detail, obviously, but if you give us an overview, that would be...
I think what Lucy said we need to keep uppermost in our mind is that the interests of the child are paramount here. And if you focus on that, I think that will help guide you as to what you might actually want to do. And we've all experienced it where somebody, it might be the parent, or it might be the parent's lawyer, or it might be the police, might come and, bang their fist on the desk and demand the notes immediately. But just remember that everyone's got time. You've got 20 working days in order to make that decision. So you can slow down. You don't need to immediately just act and print out all the notes and give it to the requester without thought. If the father has never been to the practice, you might want to think about, is he the father? Have you identified him appropriately? Have you seen a birth certificate? Have you seen his passport to make sure that he is who he says he is? And these sorts of things will help you to slow down and think about the process.
Because often, in fact, these demands are made, I need the notes by tomorrow. And there's a kind of artificial enforced urgency or sense of urgency that the practice feels, don't they, when they get these
demands? And I think, too, when they get a lawyer letter, most of us feel threatened by that, and we want to comply straight away because we think if a lawyer's written to me, it must be right. But the reality is that, I mean, we've seen it, haven't we, that it's not the case. And lawyers are simply acting for their client, and most lawyers actually don't know much about the Privacy Code at all and make all sorts of demands. So I would just say slow down and think about what you're doing.
I think the other thing here is actually Mr. Smith's written to the practice saying he wants a full copy of all the notes. The first one is going to be why. What does he want them for? Is there a court case coming up that he wants them for? Or is it because he's taking the kids on holiday and he wants to know about their medical conditions? I think actually knowing the context of the request actually helps you, because sometimes you can say, well, if you're going on holiday, you want to know their medical conditions. I'm very happy to, give you all the information you need about their medical conditions. You may not necessarily need to release all the notes.
The only thing is the father doesn't have to tell you. He's got a right to ask for the notes and he doesn't have to give you an explanation. But if you can get one, it's far better, as you say, so that we can limit the release. And obviously, I mean, there are lots of considerations, Tim, in terms of what we would think about. Now, the demand has been for the 8-year-old's notes.
All of them.
All of the notes
Sophie,
for all
Nathan,
of the children.
And Tom.
Okay.
Yep.
Well, given the age of the children, I think we need to consider them each separately. And they are separate decisions. Don't think of it as I'm releasing all of the kids' notes or none of the kids' notes, but just think of them as individual patients. And that's probably a good place to start.
Mm-hmm. Yeah, because it certainly seemed that Sophie, with her history, might have different issues from Tom, who, in fact, she never goes to the doctor, and there's nothing there in the notes that might be contentious to anybody. Yep. Whereas Sophie may not want her father to know about her sexual history and her drug experimentation. So, how does that work? How do you prevent the father, or how do you make those decisions around the father not getting that information?
For the 14-year-old, for Sophie, in New Zealand, we do follow what is commonly known as Gillick competence. And that comes out of a case from the UK where the judge had ruled that a child, or in the case of New Zealand, a person under the age of 16, where they have the maturity and understanding of the situation involved or the decision involved, and then they can, in fact, make their own decision. So for a 14-year-old, she's probably got the maturity and understanding to realise the implications of her father seeing her notes. And therefore, she's probably got a very strong opinion, and she doesn't want her father to have those notes. And so the GP can rightfully accept her decision as being refusal of consent, and he doesn't need to hand over the notes.
Yeah, it's a difficult one, this, and I think I have a couple of things I want to say. First of all, obviously, in New Zealand, the age of consent for medical treatment is 16. So Sophie is clearly under 16. But as you say, a lot of 14-year-olds do have competence. But the issue here, when her father asked for her notes, is if you put her in a position to say yes or no to that, actually that in itself can harm her relationship with her father. If in the end her father finds out that she said, no, you can't have my notes. So I think it's a difficult position to put a 14-year-old. or even more, say a 12-year-old, in a situation of asking them, do you want your dad to have your notes? These kids are often in a difficult situation between their parents anyway. They're often very conflicted about both parents and the battles that are going on. And I think really, when we're putting the kid at the top of our consideration, we've got to say, is it in the best interest of the kid for her to be making that decision? Or should I ask her to get her opinion and then actually say, no, I'm going to make a decision that it's not in her best interest to release it, rather than pushing that decision on her? I'd rather think that actually, no, if I'm the GP, I can ask her opinion, I can ascertain that she's got competence and actually take her opinion into account. But actually, I think I would like it not just to be her on her head that it's not being released, that actually I'd say that it was not in her best interest to release it.
Okay, so that's important. So you're saying that there can be actually a harm in asking a 14-year-old to make that decision, but you're also saying, but actually they need to be involved in the decision anyway. That's how you phrase it and how you work it. And then, as you say, the GP taking the responsibility for the final decision, rather than writing, your daughter Sophie has refused consent for these notes to be released, and that causing a whole can of worms further down the track.
Yes, I'd be interested to know what the Privacy Commissioner thought about it, actually. But I think that in practical terms, I think if Sophie told you that she didn't want to have her notes released to her father, you're not going to release them. I think that's a starting point, that if she's competent, then actually, and you've made a decision that she's got GILEC competency, if she says don't release them, then I wouldn't. But actually, then it's just how you're going to actually handle that in her best interests.
So you don't need to tell the father. Sophie's told me that you can't have the notes, and she doesn't want you to know that. So essentially what you would say, you don't believe it's in her best interests, and I'm going to withhold the notes. And because if she's GILEC competent, it is her right to say yes or no.
Yes. And I think then with all those situations, when you're making a decision to withhold, the father always has the right to go to the Privacy Commissioner and ask the Privacy Commissioner to overrule the GP's decision. And at that point, the GP can turn around to the Privacy Commissioner and say, well, actually, I considered Sophie to be GILEC competent, and she said no. And I don't mind telling the Privacy Commissioner that.
And often we're in a situation of advising members that it might be the right thing to do to withhold information. We will often suggest that they add into the letter, look, if you do not agree with this decision, you have the rights to go to the Privacy Commissioner and ask for their view on the matter.
And I think GPs often get a bit worried that they're going to do the wrong thing, and that actually the Privacy Commissioner is going to be angry with them for having withheld notes. But I think in some ways I'd rather have that than actually having released something and there have been harm caused. So I think on the whole, if you're not sure, you're better to not release it and then let the Privacy Commissioner make the decision. And on the whole, the Privacy Commissioner doesn't get isn't critical of GPs. I think that the Privacy Commissioner knows these are difficult decisions. And so I haven't had a case where a GP has been criticised for withholding. I've had ones where the Privacy Commissioner has disagreed and released it, but they didn't criticise the GP.
And I've had cases where the Privacy Commissioner has upheld the GP's decision and withheld notes.
Yeah, I think the important issue there is that once information has been released, it can't be taken back. You can't undo that information release. And so if in doubt, it's better not to release, because that decision can always be changed at a later stage. But once it's gone, and there's no bringing back. Now, one of the things that relating to Sophie that was a previously sort of widely held understanding was that under the Contraception, Sterilisation and Abortion Act, it was specifically stated that the consent of parents was not required for under 16s to get services, particularly contraception and abortion. In fact, that may not be the case anymore, and certainly the new Act, which was released in March last year, makes no reference to that. So if any of us out there were in the belief that that was a cast iron kind of protection for us, that is no longer the case. But what is the protection is what we've talked about already, which is the Gillick competency, and so that to him is the critical bit there.
So just clarifying that it is still appropriate to provide contraception for an under 16-year-old who's competent to make that decision.
Yep. And the issue there is whether or not it needs parental consent. So it's been legal to provide those services since 1990 when the Act was changed. But the issue is whether it has to be with parental consent or not. And now the decision is, does this person, if they don't want to get parents' consent or involve the parents in that decision, do they have Gillick competence?
Right.
To do it?
Okay. So we don't have to get parents' consent if they have competence.
Yep.
Okay.
Yep. Absolutely. Sam, do you want to talk a bit about information that can be withheld? So in Sophie's case, we're talking about all of the notes. In Nathan's case, there's just one specific thing that, could potentially cause concern.
Sure. So the clinician is in a good position to be able to decide, can I release all the notes or should most of them be released and some of it held back? And if we're going to think about patient best interests, there might be just parts of a consult or only one or two consults that need to be redacted or withheld from the father. And that becomes the clinician's decision to make. And so in the case of Sophie, it might only be those. Sophie might decide, yes, Dad can have all the consultations about the coughs and colds that I've had, and it's only the ones around contraception or sexual activity or any of those sorts of consults that need to be withheld, and that's fine. And that can equally be applied to Tom and the younger child, Nathan. Because Tom and Nathan, if the GP decided that Tom in particular was not Gillick competent, then it would be the GP's decision to work out what is in this child's best interest and should I withhold these particular notes. And there's no problem with that. I think the main thing to note is that when GPs release notes or any clinician releases notes, it must be obvious that where notes have been redacted. You can't present notes as being complete when in fact they're not. And you do need to provide some reason for the notes being withheld. You don't have to be overly explicit, but just to say it's not in the child's best interest, I think is satisfactory.
Because in fact, if you're preparing the notes, it would be very easy to do a cut and paste and just remove those bits that's
right.
And
That's right.
not say anything. Do we really have to say that we've redacted information? I mean, wouldn't it be easier if we just presented the notes as if they were complete?
It'd be far easier not to, that's true. But no, you do have to say that part of this has been redacted and the reason why. So, and as we talked about earlier, the father can go to the Privacy Commissioner and say, well, I want the rest of the notes. I think the other thing that you have to remember is to remove third-party information, which is information that doesn't pertain to the child, but pertains to another person. And that might be someone else in the family. And I think, Lucy, you were talking earlier about a case that you were aware of.
We had a case where a father requested notes and unbeknownst to the practice, the mother actually had a protection order against the father, and he didn't know the mother's address and phone number. And then when the child's notes were released, along with that release where the child was living and the phone number were released. So clearly that was a breach of the mother's privacy. And so removing third-party information, you've got to be very careful about it. You've got to make sure that any information that doesn't pertain to the child's health information is not released. And again, you redact it and you annotate the notes in that area, third-party information withheld.
So just talking about that information, so we've got to tell Mr. Smith that information has been redacted from the notes. How much do we have to explain as to why we've redacted that
I think a simple explanation is fine. I think the difficulty if you're going to be overly explicit is you're really going to release health information by doing so. I think that's the risk. So
I'm not going to release all of Sophie's sexual health and drug use information to you. Right, okay, so that's quite clear. Yep, good. All right, so what initially seemed like a fairly simple request and very straightforward actually turns out to be quite a lot more complex than what it might have been. And maybe our members won't be thanking us at the stage of the podcast for the information that we've given.
There's one common belief out there in among primary care is that if the mother says no, don't release the notes, then they don't release them, and which isn't correct, unfortunately. So one parent can't veto the other parent from getting the notes. That's not a decision that the other parent can make. It's the clinician's decision as to what notes are released. And so I think it's important our listeners are aware of that.
And not to ask, because
Don't
ask the mother, do you want me to give the father the notes? Because that's not her decision. And as soon as you've asked her, she's, you've created a conflict. So yeah, I think it's better not to ask. You do get asked about sometimes, do I have to tell the mother that the father has requested the notes? Does she have to tell?
There's no obligation to tell, but it might be unwise not to, because what you could say is, look, Mr. Smith has requested the notes. I need to make a decision about what I release. Is there any information that you think might be harmful for your child if it's released to Mr. Smith? And so you might get more detailed background in terms of what not to include, because there may be bits of the story that are significant.
Except you may not be releasing it all to the mother either. If
the mother was present at those consultations,
if she was present.
I think you do have to consider the therapeutic relationship. That as a courtesy, you could say to the mother, I'm releasing the notes because under law I have to, so that you maintain that relationship, because if she finds out another route, she might actually be quite angry with the practice. But what would you do if the father says, and you must not tell my ex-wife?
I don't think he's got the right to say that to you. I think that he doesn't have the right to say you can't talk to his ex-wife about the release. It's you have to release it to him, at least to the amount that we've discussed. But I don't think he can tell you you can't tell the mother.
Is that not his private information that he's asked for that information? It's not health information. It's not the father's health information. So
and you've got no duty of care to him.
No.
So it's an interesting question, isn't it? I think if you needed to get corroborating evidence or some information from the mother, and that was important as part of your decision to release, I think that's a different decision to, I just don't want to make her angry with me.
Yes. I think the other thing that's quite interesting is that often the practice managers deal with these requests, and they're not always in the best position to make the judgments about what needs to be released and what doesn't. So I always really encourage the clinician who's seen that child most is the right person to make the decision about what gets redacted and what doesn't. So although it's a kind of an administrative task, releasing notes, actually the decisions about what is removed or redacted really has to be made by the clinician who's involved in that patient's care.
However, realistically, we know that with the pressures on, for example, general practice at the moment, this kind of stuff having to go through and redact information is going to be at the very bottom of a GP's priority list of things to do.
Sunday afternoon job, isn't it?
But it's not the bottom of the things that might come back to bite, which could be significant. In fact, talking of that, what happens if the GP or the doctor makes a mistake? What are the potential consequences? Because if information is released that ought not to have been, then there can be a complaint to the Privacy Commissioner because of that. But equally, if information has been withheld that should have been released, there can be a complaint, or the complaint alleges that either of those things. So you're damned if you do and you're damned if you don't, really, aren't you, in this scenario? But I think, as you've said, Lucy, the consequences of releasing information inappropriately are much likely to be greater than the consequences of not releasing information and then it coming out at a later stage. And our experience would certainly reflect that, wouldn't it?
I think that the Privacy Commissioner has a tendency to want matters to be resolved. So these in terms of breach of privacy, where information has been released that ought not to have been. The Privacy Commissioner often wants there to be resolution between the parties, which often implies that he would like a settlement or she would like a settlement to take place. And in terms of all of the cases that we do, it's the privacy breaches where settlements are reasonably common. So I think that the listeners need to be very aware of that.
But I don't think in this situation where it's a release, where it's two guardians who are concerned and where it's under 16-year-old children's notes that have been released, I think as long as the GP has acted in good faith and can show that the welfare of the children was their paramount consideration, I think there's unlikely to be any significant consequence, even if they actually made the wrong decision. I think that actually, if you've tried to do your best and you've considered the children, I think the Privacy Commissioner will, they may not necessarily agree with things, but I don't think that necessarily there's going to be a significant consequence for the doctor.
No, I would agree with that. And it's usually the other cases where there's been a significant privacy breach. That's where it tends to be a settlement. Whereas, no, I agree. These ones tend to be dealt with very well.